trying to move up in the world.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Kristen Simmons, appearing on behalf of the people.
Georgia, deputy about my client's name. All right.
Okay, let's see, Mr. Trevino has exam today. This is for home invasion first, interfering with the crime report, electronic communication, domestic violence, and NDOP. It says. Okay, how are we proceeding today?
Your Honor, the people have reason to believe that Mr. Trevino is going to plead guilty to the.
Oh, okay. I'm sorry. Sorry.
The original offer I have is he's going to plead guilty to count 4, amend count 3 to attempt and dismiss balance.
Yes. So the people have reason to believe that the defendant is going to plead to the bond violation. We've received some
In the misdemeanor file. He has sentencing next week, Your Honor, on a misdemeanor. As of right now, based on conversations and some additional information I provided this morning to the prosecutor, it's my understanding that today the necessary witness is unable to. I don't want to speak for you. She's not here today. And some additional information, even if she was here today, I'm not sure the prosecutor was going to proceed at this time. So my hope.
yes. I don't want to interrupt, but so we received information from the defense that that contradicts the the allegations as outlined in the complaint.
Okay.
So we are comfortable at this time dismissing this felony case, and if in return for the defendant to plead guilty to the probation of the bond violation, and we're asking for 8 days jail.
Somebody give me that one. It's probably it's a probation. What was the bond violation?
No contact. It's this case. Contact. Alleged contact with the witness.
Okay, is he on probation?
Not yet.
Okay, but probation, he was referred to probation, that's why they have to file. Okay. And he's scheduled for next week for what?
For sentencing. And I believe the 26th for sentencing. I'm sorry.
For sentencing, okay. But he wants to plead to the violation.
Not today.
No, we're asking that we're asking for 8 days jail. We're asking that he serve those over the weekend, Friday through Sunday, if possible.
That would be on the other file.
Yes.
Not on this file. This file is going to be dismissed today.
Under the condition that he pleads guilty to the bond violation.
So I guess if sentencing doesn't work out, then they can reissue.
Why are we not sentencing him today then? I'm confused.
Sentencing in his probation file on the misdemeanor.
Well, he's not on probation yet.
Sorry.
Bond violation.
I'm sorry. His bond violation.
Someone go get me the file.
Yeah.
Please. We don't need to put off for tomorrow what we can deal with today. He's gonna plead today, complete today.
And my other question, that's why I wanted not to do it today. He has an agreement.
You're just asking me not to sentence him to jail today, is all you're asking, correct? Or why would he not plead?
Because there's a 4A status, and I want to inquire with the court what this bond violation would do with this 4A status. If you were still willing to provide.
No. There's nothing to do with, that's contempt of court.
But my understanding that it could be considered.
And you're giving, and you want him to do 8 days on the contempt of court?
Yes.
I don't want him to do the jail, but that was the agreement. What the prosecutors would do requested.
I'm vaguely remembering this. Vaguely. Was this about?
There was a domestic violence.
Yeah, there was a definitely alleged to be contacted about his children or something.
Yes.
On
He
the other,
went back to the house after he pled guilty to domestic violence, knowing that he shouldn't be in there. What happened at the house
It's
That's-
unclear
is
because
unclear, but
there's no consistencies, or there's a lack of consistency in the alleged victim statement, and the victim's not here.
yes,
Why is he doing 8 days in jail? I'm confused.
That's a recommendation. I don't-
Oh,
but he was at the house and he wasn't supposed to be there.
okay. The at the house was this case?
Yes,
And I think I might follow a question. Well, I guess when you look at the probation file, my question, more importantly, is the court gonna still follow the 4A status agreement if he was to plead to the bond violation?
Yeah, because what's that have to do, it's a contempt of court.
Because it could be considered wrongful conduct.
I get it. I don't know if I'm gonna move forward with the bond violation. I gotta see the file.
And I can provide some further information, but I'll wait for the probation file to arrive.
can I, there's a
Feel free.
witness.
I mean, because if she was in, why are we moving forward with the bond violation? Yeah. Why are we moving forward? She wasn't lying, we were dismissing the felony. Yeah. So then we gotta dismiss the bond violation. Should she be lying? They're looking for the file, Joe Fonzie statement. Right.
That's what I'm asking.
5-03820. Are you printing a nollie for the felony for the?
Yeah.
Okay. I reviewed the file. You were obviously not the attorney on the other,
On
on the misdemeanor. It
No.
was probably agreed. The misdemeanor was a case that I rejected the plea the first time because he said it was self-defense. But they pushed him, wanted to get this plea over. He said she attacked him first. So I'm withdrawing the PA 53 because I didn't think he should have pled in the first place. I don't understand why the positions are when I reject the plea, we're gonna push and try to get it through anyways. There was no offer in the first place. Run the trial. In the world, you trying to get a plea in for the original charge when the judge said it's stuff. You told me it was self-defense, but that was y'all's business. Y'all agreed to do it. If she is inconsistent about the felony, then she's probably inconsistent about the bond violation. So I withdraw the bond violation.
Your Honor, can I just say one thing for the record?
Be my guest.
I think the court was pretty clear with the terms of the bond, which was not to be within 2,000 feet of this individual while this case was pending before sentencing.
I didn't do his arraignment, so I couldn't tell you what was clear or not. I didn't arraign him.
But, Your Honor,
I could imagine that was likely what was going on. But I also could imagine that, and you should be, both of you are familiar with how these domestics sometimes go when you have people who've been in relationships for 8 years and they got kids with each other and they get back together and the alleged victim tells you, I'm not gonna go to court and come over, and you're dumb enough to fall for it. It happens. She's not here, is she?
she's not. People's position that the defendant still violated the bond condition, but
He had no business being there. I'm not saying he didn't have any business being there. He did not have any business being there. Unless there was some court order or some reason that he was there for his child. Based on what I saw in the affidavit, or the complaint for the bond violation, that's not why he was there. But that's neither here nor there. I have a issue with the underlying plea in the first place. It's because it was rejected. Because he said it was self-defense. And then we now have a felony where, again, there's inconsistencies from this victim or alleged victim. And then the victim's not here. So for those reasons, I'm going to go ahead and withdraw the bond violation on the misdemeanor, he'll continue to his plea date, or I'm sorry, his sentencing date, which is already scheduled. Any additional matters for the record?
Oh, yeah.
Nothing wrong with people.
Just for the record, the no contact order is still in place.
Can his mother be a third party? I just want the court to just put it on the record. In purpose of transferring the child, can his mother?
How old is the child?
3.5.
That's your mother?
That's my mother.
What's your mother?
AC Tribute.
Oh, I gotta put that on that file. Oh, wrong file. This one is the dismissed one.
That's right.
Not my position, counsel.
Okay, this one already, okay, hold up. At the time of arraignment, on the DV, there was already an arrangement. It says here, grandmother, Guadalupe Hall, or defendant's mother may transfer it's already there.
It's further an issue that.
I'm trying to tell you, I didn't arraign. I didn't arraign him, so I don't know what was clear, but that was already there, because obviously he didn't know that was already on there.
Or he didn't know.
Well, why would he be asking to have his mom do it?
Thank you,
Right
Your
now.
Honor. Thank you. Appreciate
Hey,
it.
you're welcome, Ned.